Right. Yes, Mr. Purchase.
So, my lord, what I hope to do in the next 20 minutes or so is first deal with your question about when arranging accommodation with a family member will fall within Part 3. And then secondly, just summarise my position with reference to Section 1710 in particular, and draw your attention to one or two further authorities in the scope.
Thank you.
Doing that. I'm not going to pick through the points in the skeleton argument at paragraph 47 onwards, because you have read that, and they perhaps are relatively, they're points of detail rather than points of principle. And so dealing first with the accommodation of the family issue, the short answer is that that might be a service provided under Part 3 of the Children Act, and it might not. And I know my lord was concerned with, as it were, assistance to enable a child to live with a family member such as an aunt. But to get to grips with that, I think we do need first to look at Section 22C of the 1989 Act. That's at page 13 in the authorities bundle. And that sets out ways in which looked after children are to be accommodated.
Looked after children?
Yes. So looked after children are, by definition, children who are provided with accommodation by the local authority.
Under Section 20 or in care.
Exactly.
It encompasses children who are in care as well as children who are accommodated under Section 20.
It does. In fact, it includes children accommodated under any social services provision, but not Section 17 itself and certain other sections.
Let's just remind ourselves the definition of looked after. I think it's in 22.
Yes.
Isn't it?
It is 22 one page.
That's right. That's it. Any of its functions, except for the function under Section 17.
Yes.
23B and 24B. Thank you.
So, as you say, it would include Section 20. And so what this says, back to Section 22C, under Section 22C3, Section 22C2, the local authority must make arrangements to live with a person who falls within subsection 3. And that includes a parent or a person with parental responsibility. Now that may obviously mean live with at their home, or it may mean live with somewhere else. But then in terms of family members who are not parents, that is dealt with in paragraphs 5 and 6. If the local authority are unable to make arrangements under subsection 2, they must place C in the placement, which is in their opinion the most appropriate placement available. Then placement is defined in subsection 6 as a list of things. It includes an individual who is a relative, friend, or other person connected with C, and who is also a local authority foster parent. So it would appear from that the provision of accommodation with a family member who is not a parent would only fall within Section 20 if that family member was also a foster parent. But my lords may know that there is provision in Section 24 of the Children Act 1989 for such people to be made temporary foster parents if the local authority thinks that that is appropriate. Sorry, it's Regulation 24, forgive me, of the 2010 regulations made under this, which... Yes. And my lord, you don't have that, but I can provide you a copy of that if it would assist. But the short answer is that it would appear from this provision that arranging for accommodation with a family member who was not made a temporary or otherwise was a foster parent would not fall within the scope of Section 20. But of course, if a local authority felt that that was the appropriate thing to do, they could always make that person a foster parent. While I'm at this section, can I just also ask you to look at
Very odd, actually. Just looking at 22 again and 22C. Provided with accommodation by the authority in the exercise of any of their functions. And 22C is ways in which they are to be accommodated.
Yeah.
But if the authority rings up the aunt and says, there's a problem between the child and the father, would you mind taking the child, and I use the words take the child deliberately, for a month, and we'll see where we are. Are they providing accommodation in the exercise of their functions, or are they, and therefore it can only get to the aunt if they've gone through all the other options, or are they simply saying to an aunt, will you do something? If you do that, then the need to provide accommodation by the authority would arise, at least for that month.
My lord, I am going to come
You're coming to that
point.
right.
I am. Before I do that, just because we're on section 22C, I just wanted to draw your attention to section 22C, subsection 6C and D, which explicitly provide that accommodation provided by third parties, essentially, may well be accommodation which falls within the scope of this Act. So subsection 6C refers to placement in a children's home, which, in respect of which a person is registered. Of course, we now know very many children's homes are privately run. Similarly, subsection D, placement in arrangements which comply with regulations made under this provision. So that is what I would say is the provision which applies on the facts of this particular case.
But you said that the accommodation provided in this case.
Exactly so, yes. So coming on to my Lord Justice Lewis's point, whether assistance which falls short of this amounts to services provided under the Act, in my submission will depend on the circumstances. And I'm sorry if that's not as clear an answer as one would like, but it is inevitably the case. Because it depends on whether that assistance is needed in order to prevent the child suffering or failing to meet a reasonable standard of health or development. If the assistance is merely, as it were, voluntary additional help, then it may not fall within the scope of Part 3. But if actually the position is that the local authority needs to provide that help in order to prevent the problems with development, then it may well fall within Part 3. And in that regard, it is perhaps worth reminding ourselves of what section 17(1) says. That's at page 3. It is the general duty of every local authority, B, so far as consistent with the duty to safeguard and promote the welfare of children, to promote the upbringing of such children by their families. So it may well be the case that steps taken by the local authority to promote that will fall within Part 3 of the Children Act. But as I say, it always depends on whether that is needed in order to prevent the failure
We're
of
in
the
the
child's
third
needs.
category in one analysis. You will say it's not voluntary by somebody outside the local authority. The authority says it's not needed in order to meet section 17(10). It's a situation, what if it's not, in inverted commas, immediately needed, but if a third party provides it, even at the request of the authority, the fact that a third party has done something and provided something means that the section 17(10) situation never arises. That may be the situation we've got here.
My Lord, yes, and you have my submissions on that, I hope. I mean,
Yeah.
I say that clearly on the fact of this case, that intervention by the local authority was needed in order to prevent the harm arising going forward, and that, again, in the circumstances of this case, this was services by the local authority. See section 22(3)(6)(d), apart from anything else.
But would there, we're trying to draw a line, would there be a situation when the activation of pre-existing facilities provided by a third party but at the request of the authority, and the provision of those facilities addresses any issue relating to the child. I'm using neutral language. Are there situations where, in principle, that wouldn't be acceptance of a 1710 situation?
There might be where the local authority is doing it not because it is needed. The local authority's intervention is not needed to prevent the harm, but in other words, the child could perfectly well do it themselves.
No, but this is
The local
different.
authority is
They're
helping.
doing it because it's not needed to prevent any harm at the moment, because the child isn't in any harm or risk of harm at the moment. But if there isn't provision at some stage down the line, then the child will become a child in need and the local authority would have to act. And the question is it permissible for an authority to say, well, we've got an arrangement as it happens with EYPP. If they are satisfied as to eligibility, even if we carry out the assessment on their behalf, can that in principle mean that you never get to a stage where a Section 1710 situation has arisen? That's what I'm grappling with.
And clearly that's right. If the child is not a child in need, then any services provided will not be services provided.
With the greatest respect, that's not directly addressing the question. The question is, are there circumstances as a matter of law where there is no imminent need for provision of any services by anyone? And if services are provided by a third party, it will prevent a situation arising where a child would be a child in need. But if that third party did not provide the services, then at some stage in the future, the child would be a child in need and services would have to be provided by the local authority.
Well, the reason I'm struggling with that question is it is to some extent circular, because a child is not a child in need unless and until the services are required to prevent him failing to reach the required, a reasonable standard of health and development. So if that is the position we're in, then any services provided by the local authority to prevent that arising in the future would fall outside the scope of the Act. But if we are in a position where we know now that within the foreseeable future, he is likely not to meet that standard without the provision of those services, then they are services provided.
Even though the eventuality may not be for, when in some cases it's a known period, perhaps when somebody comes out, as in that other case, of custody or civil accommodation.
Well, yes, and
if
obviously I'm so sorry.
Sorry, so in other words, in this case, example, say if the accommodation is provided sooner than required, as it were,
yes,
that's still provided under Section 20.
That's my case, my lord, yes.
And I think you're saying that as a matter of law. You say it's rationality, they couldn't think anything else. But you say it's rationality, I think, because you're saying that's what the law is. And if they take a different view, they must have acted irrationally because they've acted in breach of the law. That really is what it is. There isn't a question for them to say, are we close to the line? You're saying once it's needed, because if it's not provided, the child will be a child in need. Any decision not to do that would be irrational. It would be unlawful. I think it's coming close to legality.
Well, it's. I would prefer to put it this way: that it is a decision which wasn't open to them on the facts when applying the correct legal test. But that is the definition of rationality, I would submit. My lord, I would obviously accept that the further in the distance that the risk of the harm actually arising is, then the higher the likelihood of that harm may need to be in order to justify intervention under Section 17. That's another point which was made by Lady Hale in Ruby at paragraph 109, I think it was. So the likelihood standard is not a fixed one. It does depend, for example, on how imminent or otherwise the situation is, but it's not a necessary condition that the that the risk is necessarily imminent.
So the further away the risk eventuating, the greater the level of the risk has to be to make them a child in need at this point.
Yes. It's a factor.
I think 190, 190.
190, I'm sorry, I said 109, it's 190 which addresses that point under the section 31 test. But my lords, before then I just move on to what I was saying was my summary. Can I just make one final point, which is that there is no policy reason to strain to avoid a child being a child in need within the meaning of this provision. These provisions are intended to provide support to vulnerable children. There is every reason to give them a generous meaning. And in my submission, that is the ordinary meaning of the words used in this case. But it's more than that, and I've said this in my skeleton, I'm sure my lords will recognise it, but that section 1710 is a threshold. It does not in and of itself entitle a child to any particular services under Part 3 of the Act. That obligation will only arise if the conditions which relate to particular additional duties under that part are met. Insofar as there are powers under that part, it will depend on the exercise of discretion by the local authority. So I am not inviting you to apply an approach to section 1710, which is going to somehow lead to floods and floods of children with no real issues, somehow being provided with masses of support by a local authority. All that this is doing is essentially saying to the local authority, this is someone that you need to treat as potentially in need of support under this section, and obviously if a duty then arises, you must comply with that duty, which is what I say the position is in this case in relation to accommodation. So, my lords, can I just ask you to turn back to section 1710? And I will try to outline really where I am. And I'll deal with it in broadly in two parts. So the first part of the definition in subsection 10b is unlikely to achieve or maintain or have the opportunity of achieving or maintaining a reasonable standard of health or development. I'm just pausing there for the moment, and I'll be coming back to the rest of that in a second. That means in my submission that there is a real possibility moving forwards that the child will not achieve or maintain a reasonable standard of health or development. Not just now, in other words, but in the long term. The second part of the definition then is without the provision of him of services by a local authority under this part. And can I just break that down into two sub-parts? The first is the provision of him the provision to him of services by a local authority. And I just want to reiterate again that there is no dispute that the local authority provided him with accommodation. The only dispute is whether it was provided under Part 3.
I just wonder, I really do wonder whether we are not using words properly. The services, the accommodation is provided by this third party pursuant to a licence between the third party and the individual. If there is a child in need, Mr. Moffat accepts that that must be treated as Section 20 accommodation, otherwise they've breached their duty. But if we aren't into that, they haven't provided accommodation. EYPP have provided accommodation. The only thing at that stage that we know that the authorities done for this child is to refer him, and we are told that they're asked to assess the child for the third party's eligibility criteria. But unless I'm understood, I don't think Mr. Moffat is saying being in this house is accommodation under Section 20. What he's saying is if the child is in need, then we are no longer going to pretend and say it's not Section 20, because it is already prearranged under a contract with NACRA. That's what I understand their position to be, and I think Mr Moffat is nodding. So I don't think the reference to it is accepted that the accommodation is provided for him within section 10, subsection 10A. I think the answer is if he's a child in need, if they're providing services, and that doesn't include, unless he's a child in need, the accommodation, then the definition is met, I think is their case. So I don't think it's right to say the authority have accepted that they're providing accommodation for him. They haven't. They've accepted that if he's a child in need, the accommodation provided by the third party will have to be treated as if it was section 20.
My Lord, I'm bound to say I'm not sure that is the concession, and it's not the finding of the judge below. The finding of the judge below was that this accommodation was provided within the meaning of this act by the local authority.
Can we just see exactly what he said? Thank you.
I mean, I'm looking at 38, for example. Under the scheme, 8 lines down, NACRA provides support, sometimes freestanding, and sometimes in units of accommodation. And then EYPP contract is for the performance of housing related support functions.
My Lord, it's paragraph 104.
104.
8116.
This is under ground 3, isn't it?
Yeah.
Yes. That whole paragraph is worth reading, but the last sentence, if the accommodation were provided under section 20, I would consider, respectfully differing from Mr Justice Mostyn on this point, that in relation to the EYPP there would be both action by the defendant and a causal nexus with the provision of the accommodation, that it would to the necessary extent be provided by the defendant.
And then the next sentence, the next paragraph.
It's not provided under section 20, exactly. So that's the issue. The issue is not whether it's provided by this defendant at all, it's whether it's provided under section 20.
It's implicit in that there was a finding that it was provided by the local authority.
Yes. And that's a finding which my friend in his skeleton argument accepts.
Perhaps we should just ask Mr Moffat, but I just think this is quite important.
Can we look at, without asking Mr Moffat to stand up at the moment, where do you say in his skeleton is the concession on which you rely?
Uh, 23C, sorry, 23 subparagraph 3, so that's at page 10 of the skeleton. The judge held that because the council was involved in referring the appellant to EYPP, the accommodation at Bernard Brett House was provided to the appellant by the council, and the council does not seek to reopen that issue.
So we need to read the whole of 104 in the judgment.
Well, my lords, yes, but my point is that isn't something an issue in this appeal. I accept that whether it's provided under section 20 is an issue, that's absolutely an issue. But the issue that it was provided, the
By the
question that it was
authority is
provided
not.
by the authority is not an issue.
In your case, it's harder to say there's a clear distinction, at least just looking at it, if the accommodation is accommodation provided by the authority, because it then does become more difficult to say, why was it provided? It wasn't provided to avoid him getting into a situation where he doesn't need services. It's provided globally, and the point at which he becomes a child in need, i.e. leaves the family home or the two homes, must be the point at which the obligation kicks in, and you'll say on the facts, then it must be section 20.
You're saying, and I would still like to know precisely where 104 would find it. You're saying that what he's saying under 104 and 105 is it is provided, but not under section 20.
Yes.
Well, I can see where it's not provided under section 20. Where do you say it is provided?
By the authority.
So
By the-
just above that, at the end of the paragraph 104, last sentence. If it was provided under section 20,
Oh, I see.
it would be provided by the defendant.
Hang on, just a minute.
I've read that as just a different point, you see. I read it in two ways. One, there has to be section 17, and two, the accommodation has to be provided under section 20. And I understood that one of the arguments was, even if he's a child in need, this can never be section 20 accommodation because it was provided by NEST under a contract with NEST. And I'd understood that was ground two, and that they'd retracted from that, the other side, and they were now accepting that if the child was a child in need, then they can no longer argue that the provision of the accommodation in this way wouldn't be provision of accommodation by the Social Services Authority under section 20. But I don't think that's the same as saying, if we don't go down that route, the accommodation is provided by the authority and all we're talking about is the label. I think you've got to see the context, I think.
Well, my lord, I can certainly come with you this far, that if he's not a child in need, none of this really matters. But of course, part of the problem is that all of this is rather circular, because you're in a position where you're a child in need if you require services under this part, but these services under section 21 are only available to you if you're a child in need. So that's one of the difficulties, and one of the problems with the idea that a local authority can say, well, we're providing these services under a different power, because by definition you can then always avoid, whether deliberately or not, a child becoming a child in need. The point is, if these are services which are apt to fall within section 20 subsection 1 because the accommodation is not suitable, then in my submission they need to be treated as being provided under that section, and then that has a knock-on effect on whether the child is a child in need in the first place. But we do have this rather problematical definition problem, which is that both definitions depend to some extent on the other. And so one needs to focus in my submission really on the substance of the thing. But we do know from House of Lords Authority that if section 21 does apply on the facts, then the local authority must be treated as having provided accommodation pursuant to it, whether or not it thinks or says that it's acting under some contrary power. I would, if I may, just, I know I'm now...
No, well, we've been interrupted.
Time,
This is not straightforward.
No. Take you to two authorities
Yes.
on that. The first is the G against Barnett case.
Yes, Barnett.
Yes.
Yes, well, I have that open because I thought that might be That's really the only appellate authority, I think, on this, is it? Anyway, you're going to.
Yes, it is. That is the authority which decides that the general duty under subsection 1 is a target duty which doesn't give rise to any immediately enforceable.
Yes, 17.1, yes.
And also makes the point which I made earlier, which is that a child in need, as defined in section 1710, doesn't necessarily have a right to any consequential services. It will depend on whether there's a separate duty or whether the discretion is exercised. But the relevant paragraph I'd like you to look at, if I may, is at page 191 in the bundle.
I'm sorry, 191.
191.
So that's the head note.
Oh, I beg your pardon. In which case it's paragraph 66, please. What Lord Hope says there is a general point about the Children Act 1989. Second sentence, the aim was to provide a clear and consistent code for the whole area of child law. Now, that obviously is a very general observation, but it does, in my submission, support my suggestion that one should be very cautious about allowing a situation to arise where local authorities avoid falling within that code because they claim to be exercising powers in relation to children's welfare which arise under entirely separate powers. The other authority, my lords, is the Queen on the application of M against Hammersmith and Fulham, London Borough Council. That is tab 11 of the authorities bundle. And could I ask you to look at page 256?
Okay. Sorry, this is, This is my lord's case.
Yeah. And I've already mentioned.
Which paragraph?
I'm looking at paragraph 24.
Yeah.
I've already mentioned this in passing, but this is Lady Hale's observation about the importance to a child of being a former relevant child. And then the point made between letters F and G is it would not be surprising if some local authorities took steps to avoid this in order to avoid the consequence. And I'm not suggesting there's been any deliberate.
What does this add to your case?
It adds to my case because what Lady Hale is going to go on to say is that essentially that the duties under the Children Act are the priority
so
duties.
You're going on in this.
I am going on. This is the context. Then paragraph 42. Second sentence. For my part, I'm entirely sympathetic to the proposition that where a local children's services authority provide or arrange accommodation for a child and the circumstances are such that they should have taken action under section 20 of the 1989 Act, they cannot sidestep the further obligations which result from that duty by recording or arguing that they were in fact acting under section 17 or some other legislation. Now, I accept, of course, to some extent that begs the question, but the message is clear, especially when we are here in a position where, as I've said, the definitions are mutually interdependent and circular. That generally, if a child is in a position where the accommodation they're in is not suitable, so that they fall within the scope of section 20, subsection 1, a local authority should not generally be accommodating them under some other provision which doesn't
the accommodation was suitable when they did the assessment. This is the problem. It would cease to become suitable at a future stage, and actions by a third party under a contract with the local authority avoided that situation. That's the thing. These cases don't deal with it and don't help us reach a conclusion, I don't think.
My lord, I don't accept that the accommodation was suitable. Or that was, there's no clear findings.
And we can't go behind that. It's not irrational to say the situation of spending half the week with your father, half the week with your brother for a short while is suitable.
Well,
That must be a decision with the authority, mustn't it?
my lord, it would be in principle, but it's not clear that decision was made. But I do say it was irrational in the circumstances to reach that conclusion, and there is authority which supports my position on that. But I just say, as a matter of bare rationality, where a child is sleeping on the sofa in two one-bedroom apartments, where he's having to move from one to the other, where there's no stability at all, where the local authority knows that his position is that he can't access help for his mental health relating to the death of his mother until he gets stable accommodation. To say that accommodation is suitable is, in my respectful submission, just not open to the local authority on those facts. That really is, I suppose, the crux of this case. But just briefly, my lords, there is.
Well, you say that's the crux of the case. That wasn't originally the crux of the case. The case is that you said that it was, as it were, the future that you were looking at. You're saying that at that point it was unsuitable.
Yes, well, it's always been, I say, Claimant's case that however one looks at it, we satisfy the definition, because it wasn't reasonably open to the authority to decide that it was suitable at the time. Therefore, you fall within section 20, subsection 1. Therefore, you're a child in need because you.
That I understand. That's one separate case about could they rationally say they're being split between two places and being on the sofa in both, and he needs stability, or he's expressed to you that he wants stability and won't be able to move on until he's got it. You can pass the thing. That's one thing. That says that on the 31st of May 2021, they erred in the exercise of their functions because they acted irrationally, because the state of affairs on the night of the 31st of May was wrong. But we've been looking at something quite different at the moment. If you'd lost on that, and if it was not irrational to say, well, a couple of months in this kind of arrangement doesn't make it unlikely that he's going to meet the needs, there will come a time when that is the case. But if a third party steps in and provides something, then we may never get there. And that's the case that we've been looking at. And there are two different states of affairs and two different dates on which irrationality bites, if you like.
Well, I do put my case in both of them.
Yeah.
Yes.
And you say that the child is a child in need in the second circumstances, because even though the need may not arise on the second premise, may not arise until a later point, nonetheless, his case falls within the unlikelihood category because of the way section 17 subsection 10 is framed.
And my lord, really that's my submission,
Yeah.
and I won't, unless I can be of assistance, I won't say anything further except one last point, which is that it is in my submission really important in this particular case in particular to apply the language used in section 710 of the Act and not paraphrases related to whether needs are met or whether or that sort of thing, because although those are very often useful summaries of what is really being got at in section 1710, it is a very carefully worded provision, which is in my submission very much looking at the ongoing or future, whether on an ongoing or future basis the child is likely not to meet reasonable standards without input from the local authority under Part 3. And I say, as you know, that the only reasonable conclusion open on the facts of this case and on the evidence before the council was that that definition was met.
Thank you, Mr. Purchase. Anything else? Anything else? Thank you, Mr. Purchase. Mr. Moffat.
Well, Lords, if it's convenient to the court, what I propose to do is to take my submissions in 3 stages. First of all, I'm going to deal with the law. Secondly, say a little bit about the fact. And then thirdly, I hope briefly, in the light of all of that, make some submissions. Before I get to that, can I just step back for a moment and make some introductory comments? as is abundantly clear, and I think it's common ground, this is a pure irrationality challenge. It's very clear that that's the way that Mr. Purchase puts his case. He rightly accepts that a rationality challenge has a high hurdle. It has an even higher hurdle in this case, if anything, because what he has to show in order to succeed is that there was only one rational decision open to the council on the facts of this case. So the point I think my Lord Justice Lewis made in argument, it's not enough to show that the decision was flawed in some way. He has to show that there was only one outcome here that could lawfully be reached. Now, when the court is looking at that, in my submission, it's important to recognise the nuances of the position. And I obviously picked up from the dialogue this morning and this afternoon, the court does have that well in mind. When the council was considering whether or not this appellant was a child in need, it had to look at all the circumstances in the round. It had to make a predictive, evaluative judgment based on all of those factors. And of course, the court, when the court's considering whether or not there was only one decision that could lawfully have been reached, has to do the same sort of exercise. And in that respect, of course, it's important not just to latch on to one particular factor. The court will have seen that a lot of the case law in this area has some interesting features, and in a way some of those features have thrown up some of the problems that have become apparent in arguments, because most of them, in fact all of them, are looking back with the benefit of hindsight. And in most of the cases there was no real argument about whether or not the child was a child in need. There was no real argument about whether or not accommodation was required under Section 20. The real question in the case law, and certainly in the cases that went to the Supreme Court, is about the House of Lords, is about whether or not what the council did in that particular case should be treated retrospectively as the provision of Section 20 accommodation. So that's what the case law is all about. This is a different kind of case, because it's not common grounds that he was a child in need. It's not common ground that he required accommodation under Section 20 of the Act. So one needs to be very careful when sort of reading across from those other cases to the facts of this case, because there are materially important differences between them. And on the facts of this case, there are nuances. This is not a homelessness case. A lot of the cases in the authorities are pure homelessness case, where the child did not have a place to live, or at least not a suitable place to live, at the date of the assessment.
Well, I think Mr. Purchase would say that this is.
Yes, well, that's his pure rationality challenge based on the facts of this case. But certainly that's not the way the local authority analysed it. That's not the decision in this case. As been seen, I think the expression is "it's okay in the short term," which is the complete antithesis of a finding that he was homeless at the time of the assessment.
And what they actually say is it's not a long-term option.
Yes.
And the implication is it's all right in the short term.
Yes.
They don't actually use those words. But
Yes,
that's
I think some. I
implication.
mean, we'll come back. I think "okay in the short term" is used expressly in the papers.
Not in the decision, it's what the social worker's view was.
Yes.
And even then it's not sure whether it's her view or her recording the view of the
Well,
father.
I think it's if one looks at the social worker's witness statement, I think we can see that she says that that's effectively her view, because she records a similar view in her witness
Her
statement.
view that
Okay in the short term, not ideal.
that it's not a long-term option.
Yes, and I think the other expression was not ideal in the long term was the way that it was put. And I'll come back to the significance of that in a moment, if I may. We know that the relationship with the stepfather had broken down. We know that the appellant wasn't going to continue to live with the stepfather. But unlike a lot of the other cases, there were other familial relationships here. So he had other family with whom he could live, and he was living. This was not a case where the appellant was somehow estranged from his family or had been abandoned by his family. He continued to have the support of his family. Again, that's very clear from the assessment, both from his older brother and his older brother's partner and from his father. And we've seen from the assessment that the council's assessment at the time was that, in fact, they were a good influence on the appellant, that they were going to help him become independent. They were going to help him on the move to adulthood. He was, of course, at the time of the assessment, 17 years old. The problem in this case, the core problem in this case, was that he couldn't live in the long term with his brother or with his father. The constraint was what one might call a physical or a practical constraint. It was the fact they didn't have a spare room. So when he was staying with them, all he could do was to sleep on the sofa. So the essence of the conclusions, and I accept that there was the reference to mental health and the grief that he hadn't processed as a result of the passing of his mother, but the essence of all this was what the appellant needed was a place to live. The situation was not urgent, and it was not particularly serious. I don't mean to demean the circumstances in any way, but looked at in the grand scheme of things, it's okay in the short term, it's not ideal in the long term. All of the other support that the appellant required was going to be provided primarily by his family. He'd still be in touch with them, and they were still going to, the assessment was they would still support him, still help him to develop, still help him to make the transition into adulthood. There was also going to be what's referred to as early help from the council in the terms of emotional well-being support to help him process the grief. There was no suggestion, or at least no sort of finding by the council, that the appellant required the sort of the suite of additional support that comes with being a children in need who is looked after. So that's what led to the conclusion that essentially, although there was perhaps this potential problem looming on the horizon in the long term, that could be avoided if the appellant were to be accommodated through the EYPP. Now, the EYPP was something that was set up pursuant to arrangements made under Section 10 of the Children Act 2004. That would resolve what was very much a practical issue in this case. Again, I don't want to be facetious or oversimplify it, but essentially the problem here was a roof over the appellant's head. That was the core of the issue. Now, in argument, I understood that Mr. Purchase accepted that when the council was referring the appellant to the EYPP. In effect, what the council was doing is it was exercising its functions, or it's exercising its powers under the contract that it had with NACRA. That was a sort of contractual mechanism that the council was triggering. As my Lord Justice Lewis has pointed out, if one puts to one side the technical definition of provided, which is where some of that backward, retrospective-looking case law sort of comes in, because that's brought in an incredibly wide definition of provided when one's looking at the past situation, when one's looking at children who are accepted or found to be a children in need retrospectively and found to have been accommodated by the council retrospectively. That's where that very, very broad definition of provided has come in. But in any real practical sense, this accommodation, as my Lord pointed out, was being provided by NACRA. The council weren't even paying for the accommodation. The accommodation was being paid for, or was going to be paid for, by the appellant's social security benefits, by his universal credits. That's where the funding of it came from. And of course, when one's looking at what the council did here, it wasn't the reference to the EYPP that was going to address the future risk. It was the actual accommodation that was going to address this problem that was looming over the long-term horizon. And it was NACRO who were actually going to be providing that accommodation. Now, the availability of that accommodation was a matter of fact. And of course, what the court is doing here is the court is examining the council's exercise of its functions and its decision-making through a public law prism. That fact, in my submission, must be something that the council was entitled to take into account when exercising its broad, predictive, evaluative judgment under Section 1710.
The fact that accommodation was being provided.
Yes, or it was available.
But that was an option open to the child.
Yes.
Just like having a spare aunt.
Yes.
Or a good friend.
Yes. Yes. it's a question of fact. It's a point of fact that feeds into that assessment, feeds into that judgment. Now, that approach of the council, as my Lord Justice Jeremy Baker pointed out, is entirely consistent with the statutory guidance. In fact, this is exactly what the statutory guidance says a local authority should do in these circumstances. So taking all that and putting it together, in my submission, it was plainly rationally open to the council to take the view that in this case, the appellant did not need to be provided with services under Part 3 of the Act. And of course, that's an important part of the Section 17 definition. It's not just the provision of services by a local authority, it's the provision of services under Part 3. It's very specific about the type of services. And the council was therefore rationally entitled to conclude that the appellant was not a child in need. So that's basically the council's case in a nutshell. And sorry.
I can almost look at it like this. There were 10 months before age 18. On your case, for 4 months, it would be suitable. If it carried on after 4 months to 18, it would be unsuitable. But there's an intervention. There's the NEST accommodation. On the appellant's cases, there are 8 months. You look forward for those 8 months from the date of the assessment. And where at month 4, there's an overlap between accommodation being provided by NEST pursuant to a contract with the authority. At that stage, there is then a match between the accommodation and the child needing accommodation. And bingo, therefore, to say it's anything other than accommodation for a child in need would be irrational. That's the difference, really. You say there's a sequence of events and the accommodation may be one thing that breaks it. I think your opponent says there's a continuum, and when a time comes when there's an overlap between the provision of accommodation, because he needs it, and the child needing it, at that point, if not earlier, it becomes a child in need, or even that point is going to come, therefore he was a child in need at the very start of the continuum.
Yes, well, that's the, and I suppose that's the circularity, I think, that
Yes.
Sir Leonard Fred referred to. And I mean, I think in a way he's right about that. There is a circularity here. And in a way, the circularity has been introduced by two factors. First of all, as my learned friend said, I mean, the section 1710A and B definitions sort of bring in the concept of services under Part 3. So the definition that Parliament has laid down has to a certain extent introduced that element of circularity. So in a way that's sort of inevitable. And of course, it's going to be for the court to decide how to sort of cut that particular Gordian knot. The other element of circularity has, to a certain extent, been brought in by what I said about the case law, and particularly the House of Lords and Supreme Case Law, that in looking at these cases where there is no dispute about whether a child is in need, and adopting a very elastic definition of what constitutes the provision of accommodation in order to bring a cohort of children within the protection of the Act, retrospectively, so that they can be treated as a former relevant child. The courts have expanded the definition of provision in a way that it's gone about as far as it possibly could.
I think what they've done is they've treated or deemed that which has happened
to have been provided. Yes.
Provided. That, I think, is what happened.
Yes, and sorry, Your Lordship, I perhaps putting it a bit loosely, but Your Lordship touched on exactly the point that I was going to come to, that when the courts have done that, they've been in effect exercising that deeming, undertaking that deeming exercise. But as I said, this is not that case.
But surely the question whether a local authority is providing services under Part 3 should be the same,
Yes.
whether you look at it forwards or backwards.
Yes, no. I mean, Your Lordship must be right about that. I mean, it's very difficult.
So why then isn't it appropriate to look at the retrospective cases?
Well, no, I'm not saying it isn't appropriate. I'm not at all saying it's not appropriate to look at them. But
there is a difference between saying, looking back, this person is recognised was a child in need, and therefore what happened is to be treated as if it was accommodation, and a different exercise saying we don't know whether or not the child was a child in need. And you can't say, because it would, if it were a child in need, be treated as accommodation. Therefore, that's proof that that's a child in need.
Yes, I mean
That's the sleight of hand.
that in itself is circular. I mean, I mean, one might say there's circularity on both sides here. One might say, but that's as it were inevitable. But what I say, the correct approach here is the pure public law approach that I've outlined. That what the court should do, what the social worker on the ground should do, is look at the facts. I mean, one needs to have an element of pragmatism about all of this. I mean, one knows that social workers are extremely busy, they're highly pressurised, they're dealing often with stressful caseloads. And a sort of forensic examination of sort of how the legal provisions work in theory is perhaps not going to be something that comes particularly easily or readily to the people who have to operate on the ground. What the people who have to operate this on the ground can do is just look to the factual situation. Now, I appreciate that there may be concern about, well, this I think is at the heart of my learned friend's case. Well, this is going to allow local authorities to sidestep the protections of the Children Act. This is going to allow local authorities to, in effect, set up parallel systems in order to evade their duties. But public law also has the answer for that. I mean, if a local authority starts doing that sort of thing, there's going to be a Padfields challenge. A local authority can't purport to exercise its powers, whether it's under the 2004 Act, whether it's under the Localism Act, in a way that seeks to evade its responsibilities under another act, because that will be unlawful in itself. So that, we say that's where, if there is circularity, that's how to I'm mixing my metaphors, how to cut the Gordian knot. That's not just mixing, that's mangling the metaphors. And it is this sort of, what I've described as a sort of pure public law approach that's to be adopted in these sorts of cases.
So the appellant couldn't win on rationality in your case, but could win if the decision was done for an improper purpose.
Yes.
If they said, we see the writing on the wall, let's do this quickly. So
We're trying to
we don't
save
have
money
do our
or-
duties, yes.
Or whatever it might be. There's no suggestion of that. I mean,
Case.
there's no suggestion. I mean, I know the appellant says, well, I wasn't happy with what I was given in the end, but there's no suggestion that the social worker and the manager here were trying to do anything other than was best for the child. And to pick up on a point that my Lord Justice Jeremy Baker made about the early help and about what the statutory guidance says. I mean, it's about trying to stop a situation deteriorating. That's what was happening here. There was the possibility. I don't want to get into balance of probabilities, but there was the
risk.
The
There was a
risk
risk.
looming. Please use a neutral word. Risk looming over the horizon that things might go wrong here. That the situation, either continuing to be sleeping on the sofa, was going in itself to harm the well-being of this particular appellant, or that the brother or the father would just get fed up and say, well, you're not staying anymore, and they would find themselves literally homeless. That was the risk. That's what the local authority was trying to stop. At that point, of course, if that happened, he would have been a child in need at that point. But the local authority was trying to stop things develop to that point. And this is exactly the concept of the early help, that not only in the homelessness guidance that my Lord referred to, it's also in the working together statutory guidance.
Yes, well, that's the one I'd not seen. I missed that guidance.
Yes,
Yes. Referred to, but
but
it's
then-
there, albeit it's in a footnote, isn't it? It's not.
Well, it's not just a footnote, my Lord, because it talks about early help. It talks about elements or possible examples of early help being securing housing, or ensuring that housing is secure. I can't remember the exact wording, but secure
Okay.
housing is the gist of it. So the statutory guidance is encouraging local authorities to do what this local authority did in this case. Now, it may be that the statutory guidance is unlawful. That's not part of the case that's mounted today, but it would seem to be one of the implications of the case that is being mounted today, that at least the two secretaries of state have got the law wrong in this respect. And in fact, this concept of early help, this idea that one can step in before things escalate to the Part 3 level, is something that local authorities can't actually lawfully do. That's where I think the logic of the appellant's case takes
But
one.
it actually is also, I was going to say, but only in relation to housing, but it's not actually.
It's
because
everything.
It's the therapist example that I gave.
It's everything. So,
Can I just ask, sorry, it's only for me, I've got the problem. Does it make any difference whether the, in fact, on your argument, that the accommodation was provided by a third party, or in fact, if it was, provided by a local authority?
provided the local authority had a power to do it that was outside
Well,
Part
that's what I'm
3,
saying.
then no, it wouldn't make any
You
difference.
said they did have a power.
Yes, yes.
Yeah, so that you say that's not actually
That's not actually the crux of this. No, no. I mean, the classic example of what might, I say classic example, I've slightly come up with it off the top of my head, so I'll probably be told it's not a very
A
good
thought which comes to mind, which may be
which comes to mind.
which may be the classic example after we've
But if Mr. Purchase is allowed to have them, I'm allowed to have them, I suppose. For example, one might think of a situation where a child, there is a looming risk of, to put it in very broad terms, something bad happening in a child's case. Now, the local authority might think, well, actually, if we provide some education services under the Education Acts, that might stop this particular situation developing, getting to the point where there is a, whatever level of risk it is, of risk of the child not meeting the sort of adequate standard of development. Now, again, the logic of the appellant's case is, I think, that because Section 17 is so broad, and because Section 17 allows a local authority to in a way, do almost anything, there might be arguments about whether there was expressio unius, exclusio alteris, but in broad terms, the local authority wasn't allowed to exercise its functions under that very specific statutory regime, because what it was doing is it was providing a service to the child that automatically brought it into Section 1710 territory, and therefore anything that it did had to be deemed to be provision under Part 3 of the
Well, it's a
Act.
fundamental principle that intervention in family should be the least interventionist suitable to meet the
Yes.
child's need. That's,
Yes.
that's Article 8, etc.
Yes, and I mean that's the whole point about early help, is one steps in early to stop things getting worse, and that's what happened here. I mean, what I made the point before about this wasn't the case where the local authority acted in bad faith or was acting for an improper ulterior motive or to try and save money. I mean, on the facts of this case, it may well have been open to this local authority to say, well, everything's okay now, might get worse in the future, might not, something might come up, we don't know, but it's a long way off, so thank you, but we're not going to give you anything at all.
And this case, then, on your analysis, would only become a looked after case if they had said on the 31st of May, this can't go on any longer.
Yes.
This child can't stay in this apartment on this sofa one night longer.
Yes.
And they ring NACRO and they say, please provide something quickly. And they say, yeah, we will.
Yes.
That would have been one situation, you see.
I'd have been struggling to argue that it
Yeah.
wasn't a child in need in those circumstances. Now, one can think of a whole spectrum of factual circumstances.
Exactly. And then they might say, well, you know, we'll put up with this for a week, but something's got to be done. But you say when it's long term versus okay in the short term, and there's the prospect of intervention in the short term, which prevent the long term materializing, that's different, you say.
Yes. Yes.
Or you say it's a question of rationality, and this is, yeah.
Yes, rationality. And again, it comes back to what is, and it may well be, I mean, the court will obviously, and I'm not pretending it's straightforward. I mean, there are difficult issues in this, of course, and there is the issue of circularity, which does raise some questions. But ultimately, in my respectful submission, the analysis has to come back to that public law. This is a judicial review. The analysis has to come back to the public law analysis. And that means looking at the conventional grounds. And what are the grounds? The ground here is irrationality. It's not illegality. I mean, my lord offered that to a learned friend, and he didn't take it.
It was a bit of a poison challenge. wasn't it?
Well, it might, yes. I mean, I'm not suggesting my learned friend was wrong.
And what he's done, I think, is to say
He's trying to
it's
ride two
irrational
horses.
because the legality, etc.
Yes, he's trying to have his cake and eat it. I think is perhaps I may be being unfair to my learned friend. I don't mean to be.
Now,
Yes, sorry,
I think this is still your preamble.
Well,
we're going to come onto the law, the facts, and
I
then
mean,
permissions. I have a feeling you might be going in reverse order there.
well, yes, perhaps I'll try and take it fairly quickly because I think that the court has the nub of the point.
Yes, for my part, I would like to hear a sort of straightforward submission from you on section 1710.
Yeah. Okay. Well, can I take it through then? So the first point, and again, I think it's common ground, is that the question of whether or not the child is a child in need is a question for the local authority to determine, subject only to conventional public law challenge. That's very clear, I think, from the case law we've cited in our skeleton argument, BC in Newcastle and the judgment of Lord Justice Mumby in that. So the definition of child in need, again, we've cited in our skeleton argument. I won't take the court to it in the interest of time, but it's at paragraph 27 of our skeleton. It's a reference to paragraph 26 of A in Croydon, which was the age assessment case, where the Supreme Court held that the question of whether or not an individual is a child or is not a child is a question, in effect, of precedent fact for the court to determine. But in the course of that, in the course of her reasoning, Baroness Hale examined the distinction between the question of child and the question of in need. And she made the point that the question of whether a child is in need requires a number of different value judgments to which there are no clear right or wrong answers.
Should we just look at
Yes,
that?
of course. It's tab 16, page 370. I hope page 370. Yes, it's paragraph 26.
No, I wasn't there. Happily, yeah.
Okay.
So the context for this, your lordships may be aware, is that the question for the court on this occasion was whether or not the issue of whether an individual was a child, was over or under 18, was a question for rationality.
It was a precedent fact.
It was a precedent fact. And part of Baroness Hale's reasoning in deciding that it was a precedent fact was she drew contrast with other questions within the Children Act. And one of the contrasts she drew was with the question of whether or not a child is in need within the meaning of section 1710. So this is what we see in 26. She's dealing with that. She's drawing that distinction to the reader's attention. So the question whether so the 1989 Act draws a clear and sensible distinction between different kinds of question. The question whether a child is in need requires a number of different value judgments. What would be a reasonable standard of health or development for this child? How likely is he to achieve it? What services might bring that standard up to a reasonable level? So that's dealing with 1710A. Then she goes on to, in the next few questions, is 1710B. She refers to the fact that sometimes questions like this are decided by the courts in the course of care proceedings. She says there, but where the issue is not what order should the court make, but what service should the local authority provide, it is entirely reasonable to assume that Parliament intended such evaluative questions to be determined by the public authority, subject to the control of the courts on the ordinary principles of judicial review within the limits of fair process and whence be reasonableness. There are no clear-cut right or wrong answers. So, making that, I think it's common ground. It's judicial review or nothing in this particular case. It's not. It was the point I made to my Lord Lodger Speaker first thing this morning. It's not for the court to decide. It's for the court to decide whether or not there was only one rational option open to the authority. So the question
shows the opposite. Is a person a child? You either are a child or not. You've either been alive for 17 years and 366 days, or you haven't.
It's a question of objective facts that a court can and now does determine. Yeah. So the questions. What would constitute a reasonable standard of healthful development? Now, bearing in mind how those are defined in section 1711, that involves consideration of a whole range of factors, potentially, in a particular case. Is the child unlikely to achieve that reasonable standard? I'll come on to likely, unlikely in a moment. And if so, are services under Part 3 required to make it not unlikely, if we exclude the double negative, that he will achieve that standard? Now, that latter question, in my respect, has to involve consideration of what other support and services are going to be available to the child, not least the support that the child might receive from his or her family. Now, it's common ground that in some cases, at least, this is going to be forward-looking. There will be some cases where one can say here and now, this child is not achieving a reasonable standard of health or development. But there will be other cases in which, to use my Lord's expression, there's a risk in the future that the child won't achieve it. Now, that's what introduces the element of predictive judgment. But the fact that there's an element of predictive judgment in all of this reinforces a point that I've already made, that the judgments that are required under Section 1710 are judgments that a local authority is particularly well placed to make.
I mean, it is forward-looking. The more one looks,
Yes,
one looks at it,
yes.
because it's talking about achieving or maintaining.
Yes.
So achieving is something you haven't achieved.
Yes, the only reason there's been something of a debate about this in this court is because in the court below, and this is something to take into account when one's looking at what the judge said and how he dealt with the definition of child need. The appellant's case, or the claimant as he's on there, was that at the point of the assessment, he was homeless. So Mr. Purchase's sort of backup case today was the primary case below. Indeed, it was the only case. Perhaps a bit unfair, but it was certainly the primary case was as at the date of the assessment, he was homeless. So these issues about forward-looking were not in play before the judge, because that's not what was being argued on behalf of the claimant below.
I've slightly distracted you with that intervention, for which I apologise.
Sorry, it's probably my fault.
No. Well,
So I was saying,
your point is that the point you made a moment ago is that is in assessing whether he is unlikely to achieve a reasonable standard, etc., without the provision of services, you have to consider, under Part 3, you have to consider the other provisions that are available for
yes,
him.
wherever it comes from.
And that can be from family or from other agencies or from the local authority, other underparts. Do you say other under provisions? Do you say that?
Yes, I mean this is a question of fact.
And actually, it logically, that arguably might have to be the case. If you're looking now, is he in need? And you say, well, no, he's not in need. He's living with his mother and father and he's happy. Will he be in need in the future? Well, he may be, because his mother and father are about to get divorced and they can't stand each other anymore, and neither of them will have the child. And you say, well, what's going to happen next? Well, it's all right. The aunt will have him. Well, the aunt's not going to take him. Well, don't worry, there's an actor down the corner. That's what you say should happen.
Yes,
By definition, if you're looking at needs that might arise, you must also look at services that might
yes,
arise.
your lordship has picked up on almost exactly the same point was made by Lord Phillips for the Court of Appeal.
Well done.
Should be promoted then, yeah.
And again, we've cited
anticipated the point.
it. We cited it. It's the case of P. We've cited it in our skeleton ordinance. It's
Oh,
Court
I,
of Appeal
I
case.
promise you I didn't read it. It's my own
And,
idea.
and the point, the very short point that Lord Phillips makes there is all children have needs.
Yes.
They all have needs that have to be catered for by somebody. I mean, maybe when one gets to an older child who's 17, perhaps that might not be the case. But the point of so in a way, all children in a colloquial sense or in a literal sense are in need. The question is, who's going to meet those needs? And the point of Section 1710 is to identify those children whose needs can only be met by local authority intervention under Part 3.
All children are going to. Most children will be unlikely to achieve the standard what they're capable of without help from somebody.
Yes, that's exactly the point, Lord.
Maybe every child, but certainly most children.
So one has to accept that the local authority is, at least to a certain extent, allowed to look at support that might be provided elsewhere, because otherwise every child is a child. Almost every child is a child in need. So then the question becomes, well, what's the basis for drawing a line? What is the restriction on the facts that the local authority is allowed to look at when making that assessment? one has to have a reason for drawing a line somewhere, and one has to be able to identify where that line is drawn. Now, one doesn't find that, I say, in section 1710. This I would say, is a straightforward relevant considerations point. What is the local authority allowed to take into account? And again, I mean, having Mr. Purchase might say, well, you know, it's implicit in an irrationality challenge that you could have it as at Wednesbury irrational consideration. But this case has not been put on the basis that this is something that a local authority has to leave out of account when exercising its broad evaluative judgment under section 1710. And that's really, I mean, in a way, again, I keep saying this is the nub of my case. I'm getting repetitive, but on an analysis, on a public law analysis, that in a way is where the appellant has to get to. Why is that? Why are those facts the fact that support might be provided by mum and dad, might be provided by auntie, might be provided by a charity with which the child is involved, might be provided by the school? Whatever else the party might be provided by this other department in the local authority. What is the conceptual reason? What is the forensic reason why section 1710 requires that to be left out of account? And in my respectful submission, there isn't one.
Can I just ask, do you accept that it would have been open on facts on this case for them to determine? I know they didn't, they did the opposite, but you say, but would it have been open to them to say that he was a child in need? Bearing in mind the matters about the future, etc.
Well, I think I would struggle to say that it, given my points about the broad evaluative judgment, about the scope of it, discretion is the wrong word because it's a judgment that the local authority has to undertake. I think I might struggle to say no, but I'm just trying to think through what the implications of that might,
may not be any.
might be. But as Baroness said, there are no right or wrong answers.
They surely could have been able to say, this is a tough situation. He lost his mother at 14. He's struggling. He's on a sofa every night of the week. Things will get bad if we don't do something about it. And we are going to do something about it. That couldn't have been a wrong decision.
Well, no, when your lordship, yes, I mean, I think your lordship must be right. When
Yeah.
you put it like that, I think it must have been a rational, at least one rational.
Yes,
Maybe
rational.
they
This
did-
was one of a range, and in this
Yes.
case, they took another
They
decision,
took-
which you say would be rational.
They took it, but they didn't take the most extreme view, which would have been, well, we're not going to do anything, just get lost.
Legally possible, just so that people in court know, we might have reached a different decision
Yes.
from this authority. One, at least, and possibly two or three of us might think if it had been us, we'd have cut the cake differently. We'd have said, no, this child needs help. Others, like your Clyde, said, no, not that bad. And it depends. It depends on the view you take.
Yes, and I mean, we've got it in the bundle. Of course, local authorities have what are referred to as eligibility criteria. They're allowed to have that. They're encouraged to have it by national guidance, where they set out the sorts of needs that they say will tip over into the child in need. They call it statutory services.
Yes.
And they try to have some consistency in their decision making. And indeed, if one looks at the criteria that Essex have, which there's been no challenge to, problems with housing come under the sort of early help, specific early help type criteria. So
We very much, sorry for my part, we very much focus in on obviously accommodation for a very good reason why
yes,
that was the accommodation that the service was provided, and it has implications for the future, etc. Is there anything particular, do you say that there is anything particular about the provision accommodation, the impacts with section 20, that different criteria should be in play that would preclude the local authority from not taking that into account, the provision of accommodation under different power?
Sorry, I'm sorry. I'm not. Could I?
Sorry, in other words, we very much focused, haven't we, on accommodation?
Yes.
For obvious reasons. Does that have any, in this particular case, does that have any implication? Does that make a difference in this case? You're talking about the type of services that could be provided by the local authority. We're talking in this case about accommodation which was provided. Does that make any difference or not?
Well, in principle, I would say no, and this is a point I would say in my favour, Lord, because as has been discussed in the course of argument, the sort of provision that a local authority might make is potentially incredibly broad. It can range from, I suppose, accommodation is at almost one end of a spectrum to fairly low-level types of interventions. Now, in almost all cases of intervention, that is, in theory, likely to be possible to deliver within Part 3, whether under Section 17 or Section 20. So the fact that this approach has to be adopted to the full range of services that might be provided under Part 3, in my submission, supports my argument, because if for example, a relative, not the mother and father, or a charity were to provide a very low level of intervention, falling far short of accommodation, and that were to mean that somehow automatically the child were to be brought into the child in need regime, that would go even further to undermine the sort of early help type structure that central government has very much encouraged local authorities to adopt.
I think the one caveat we need to bear in mind, and given the decision of M, is if an authority has assessed a child to be homeless or threatened with homelessness, then it would be very difficult for them not to use Section 20 or anything else. I think your case must depend on it was suitable in the short term and it wasn't going to be brought to an end.
Oh no, absolutely, my lord. I don't
caveat, otherwise you'll.
No. I quite accept that, and in a way that, presumably forensically, this was the reason why in the court below the appellant's argument was I was homeless at the point of assessment, because if he managed to persuade the judge of that, he effectively he pretty much got himself over the child in need threshold. So no doubt there was a good forensic reason why that was the case in batch below. Whereas the difficulty with the main case that's being advanced now is, of course, it doesn't have that almost immediate link.
If he was homeless at the time, then the provision of accommodation, whatever the labour or the route, was meeting.
It would be.
If he wasn't homeless at the time and they assessed he wasn't in need, the future prospect of accommodation becoming available through the NEST source may prevent the children in need situation arising. So there's that caveat.
Yes, your lordship's absolutely right, and I hope I didn't give the impression that I was seeking to go.
It's just in case we forgot that.
Go any further than that, and of course that's why the facts of this case are so important. The nuance, as I put it, the nuances of it. Because it's not an immediate, well, I know Mr. Purchase says rationally it had to be, but my basic submission on that is it was open to the council rationally to decide that he wasn't homeless at the point of the assessment. On that, in my respect, this is not a homelessness now or a homelessness in the immediate future type case. It's the long term. Sorry, I seem to have got diverted again. Can I deal very briefly, just briefly with the question of unlikely, because I don't think there's a huge amount between the parties on this, but there's one point that may be worth emphasising, that may be a point of difference. Now, I've already accepted that it's forward-looking, as my Lord Justice Baker said, that it's really implicit in Section 1710 that it is forward-looking.
Unlikely to achieve.
Yes, or may involve sometimes looking solely at what's happening now. It may involve looking down the line. I also would accept that it doesn't necessarily involve the importation of a balance of probabilities test. And in fact, certainly my instructions are that's not what social workers do on the ground. They don't do a 50-50 sort of exercise. As we've seen from Ruby, and as the court will be well aware, of course, balance of probabilities is generally something that's applied to deciding what's happened in the past. It's much more difficult to apply it to predictive judgments as to what may happen in the future, particularly in cases such as these, where there might be lots of different interlocking factors. One thing I would urge caution about is substituting another set of words for unlikely. I would suggest that expressions such as real possibility or could well happen might be useful shorthand, but they should not be used as a substitute for the statutory words themselves. Unlikely. The real question is, what does unlikely mean? And that's a question of substance rather than a question of labels. And I think when one looks at the judgments in cases such as Re B, also the Boyle case, which has been cited by my learned friend, that's what the courts are doing. They're not saying it's some other statutory words. They're using a shorthand to describe a process, as it were. And one needs to be a little bit careful about it. Essentially, the process that the courts have adopted, both in the disability discrimination context, which is the Boyle case, and in the care order case, which is the in Re B, is that likely, unlikely has shades of meaning depending on the context. Particularly where one's concerned with predictions, generally Parliament doesn't use it to mean a strict 50-50 threshold, and really the question is whether or not the risk is significant enough to justify intervention. That's essentially the approach that the courts have adopted. It's really about looking at a constellation of factors. So what is the risk that we're talking about? How serious, how grave is the risk? How far in the future is it? How likely do we think it's going to be? And in a way, it is an evaluative judgment that the social worker has to undertake. And the themes that emerge from that case law, I think we would accept, would apply in this particular context. But when one's looking at the judgments that social workers exercise, one has to look at all these things. It might be that a lower risk of a very serious harm to a child would justify them being treated as a child in need, but a higher risk of a much lower form of, I'm using harm, shorthand here, would not justify them being treated as a child in need. Ultimately, as with all these things, it depends on the circumstances.
That could be regarded, if we were to endorse that and repeat it in judgments, it could be regarded as a gloss.
Well, we wouldn't want to have a gloss. I mean, yes, but I mean, I suppose really what the court needs to do is decide whether or not what's happened here and whether or not the judge applied the right test, and I suppose ultimately whether or not the local authority applied the right test. And it may be a question that the court doesn't actually need to determine, because the court may decide, well, whatever sort of threshold we're applying on the facts of this particular case, it was rationally open to the local authority to reach the conclusion that this child was not a child in need, bearing in mind certainly the low level of the current risk, if I can put it like that, the fact that things were okay at the moment, the fact that what was foreseen in the future was not seen as a grave risk, it was not ideal, and the fact that it was, on any view, seen to be at least some time away. It was a long-term, potentially a problem in the long term. And that looking at those factors, the local authority was sort of, even putting to one side the availability of the other accommodation, the local authority was entitled to say that on the facts of this case, this was not a case in which the child was unlikely to fail to reach a reasonable standard of development.
I just wonder, just thinking now, whether that is correct. Actually, I'm not sure if one can determine unlikely by reference to the magnitude of the damage that would happen if it materialised. That may be relevant to reasonable standard. Child won't have the ability to read or whatever. Most of us would think reading is about. A child wouldn't have the ability to develop a musical talent. The risks of that happening is what's in unlikely. If the child can't develop a musical talent, may not mean that the reasonable standard has arisen. If it is reading, which most of us would think you have to be able to do in the modern world, and if it's unlikely to happen, then that's it. And I think unlikely is how likely is it to happen. And I don't think that the amount of the damage tells you much about how likely or unlikely it is.
Well, it doesn't. Yes, but your lordship's absolutely right about that. It doesn't. I mean, if
I'm not going to run the risk of a nuclear disaster. I might run the risk of, I might run the risk of getting a fine for going too fast at the weekend. But that's different from this kind of thing. There are fixed things. How likely? What is reasonable?
Yes, well, I mean, I see your lordship's point. I mean,
Yeah.
one obviously can't, when one's assessing, it's difficult to sort of avoid this without using the same language, the chances of something happening, that's in a way, a sort of objective assessment. It might be a difficult assessment and it might be a predictive assessment, but it's an objective question. I suppose where the case law seems to be leading, and this seems to be what Mr. Justice Lloyd Jones, as he then was saying in the Manchester case, about when he talks about the possibility of problems arising in the future, is that when one's looking at whether or not a child is a child in need, it's sort of the point that your lordship made against me, as it were, that the more serious a risk, the more sort of precautionary approach that should be adopted.
I'm not sure that you could measure it like that, actually. On the facts of this case, if it's unlikely that the appellant would be able to access social benefits, universal credit, unless the local authority helped him, then that's it. It doesn't matter how great or bad that is. The thing is, if he can't have money, he can't live, he can't get food and so on. So I don't think the harm is relevant, or the nature of the harm is relevant to the likelihood. It may be relevant to reasonable standards.
Yes, well, it would certainly, I suppose, be relevant to that. And I take your lordship's point. I mean, I certainly don't want to dissuade the court away from if the court is minded to read the words literally.
I think this is a bit of a cul-de-sac myself as well, for a slightly different reason.
Yes.
Coming from my you'll appreciate I have
Yes.
more experience of Part 4 of the Children Act, and the Children Act has a hierarchy of local authority intervention, of which the bit we're looking at, Section 17, is the lowest level, the first stage within the Act. And there are, under other provisions, early help under the Children Act 2004, there's an even earlier provision. When we're talking about the degree of harm a child may suffer, then I think we're in danger of straying into areas where the Act has different provision.
Mm-hmm.
So if there is a likelihood of significant harm, then the local authority will be thinking about its powers under Part 4 rather than its powers under Part 3.
Yes. Well,
And the whole point of Section 17, the first part of Section 17, all of Section
stop that
17
happening.
is to Section 17's 2 to 11 are really there as supplemental to Section 17(1), where the duty is to the general duty to provide, safeguard and promote the welfare of children, and so far as consistent with that, to promote their upbringing of children within their families.
Yes.
By providing a range of services.
To stop one
So the
getting into
1710 is
Part
part of that.
Yes.
So for that reason, which is similar but not quite the same point as my lord was making, I think it is a bit of a cul-de-sac. If you sort of say, well, the level of likelihood varies depending, or unlikelihood required varies depending on the type of harm.
I take your lordship's point. I mean, it may be that I can't take this point very much further forward. I mean, in a way, it's a point against me, I suppose. I mean, it reflects what I understand certainly social workers at Essex do on a practical basis. Perhaps they don't analyse it in quite these forensic terms, but it's the sort of approach that is adopted pragmatically. Which is
Any
why
social worker watching this on the live stream will be holding their head in hand.
well, we have some social workers in the room, so
I know they're not holding their hand.
I haven't been kicked yet. It may happen afterwards.
Anyway, I think we've.
Well, I'll move.
What
I'll
you
move
want
on.
to say on 1710, if not, or any other part of the statute, or any case law, you're dealing with law.
Yes, I'm dealing with law, and I am conscious of the time. I think just can I just take so that's I'll park unlikely for the time being. Can I just move on to the final part of the the section 1710 definition, the provision of services under
Yeah.
under this part, which, as I said before, is very important. And can I just take your lordships to, I think, one authority, which I think encapsulates the points. It's tab 17. It's Lord Justice Mumby again, in the Divisional Court, as my Lord friend pointed out.
This is Newcastle.
This is the Newcastle case. So the dispute in this case was about failed asylum seekers and the provision of asylum support under Section 4 of the Immigration and Asylum Act 1999, which is provided by the Secretary of State, and there was effectively a dispute between the local authority and the Secretary of State who's responsible for providing support for these families who had children. And if I can just pick it up, what Lord Justice Mumby said about the children in need criteria from paragraph 29.
Yeah.
So it's page 392 of the authorities bundle. And this picks up the point from Lord Phillips that I mentioned to my Lord earlier. So the final words of the subsections are important. The duties of local authority do not extend to all children who might be said to be in need. Apart from a disabled child, they apply only to a child who, without the provision for him of services by the local authority, will fall into one of the other statutory criteria. As the Court of Appeal put it in the case of P, the distinguishing feature of a child in need for this purpose is not that he has needs. All children have needs, which others must supply. Until they're old enough to look after themselves, but those needs will not be properly met without the provision of local authority social services
Under Part 3.
under Part 3.
Not said, but that's what the statute
And then
said.
30, it follows that a child who in the colloquial sense is in need may not be in need in the statutory sense if his relevant needs are being met by some third party, for example by a family member, by a charitable or other third sector agency, or by another statutory body. So the point that the court was discussing with my learned friend dealt with there, and we see a quote there from Lord Justice Mumby in the Howard Lee case.
Yeah.
And then just over the page, finally, to conclude where he deals with this point, paragraph 31, an illustration of the principle in operation is provided in the Plymouth.
Yes.
I'm afraid
We haven't got that, have
I'm
we?
afraid, I'm sorry.
I was looking at that for that earlier this morning.
We don't have that, I'm sorry. Where the local authority thought without any objection in principle to its approach to arrange for the provision of accommodation which a Section 17 assessment had identified as needed for a child and his family either through the public sector or under the Housing Act, or alternatively in the private market.
So that under the Housing Act would be with a housing association, would it?
Well, I'm afraid I don't know the law.
At this point, rather unlikely to be a local authority accommodation, it would be a housing association. Anyway, perhaps we need to look at that.
Yes,
case.
I'm sorry. We perhaps should have put that.
But
in
again, that is a first instance decision.
Yes, of course. None of this is binding. Of course,
But
what Lord Justice-
it occurred to me reading this earlier that is a case on all fours with your case.
Well, what Lord Justice Mumby says here is very much
Is all-
supportive
yeah,
of what I say.
yeah.
Yes, absolutely. I mean,
And that, but again, he is the Newcastle case is not an authority. All this is slightly obiter, isn't it?
yes. Well, I'm not.
Because he was talking, as you said, about asylum.
Yes, yes. No,
So-
I'm not going to say. Of course, it's divisional court. I'm not suggesting it's anyway binding, but certainly it's at least supportive of my case. I think that's as
Well,
far
he
as I
says
can
it's
put it.
supportive,
What
and even though this decision isn't on the facts of what he's saying here is what he's summarising in which he often did, the legal
Yes,
principles, which don't, but they're not. The decision in Newcastle is
didn't turn on this.
but it looks to me as though the Plymouth case might have turned on it.
Yes,
The
well,
way,
and
and
I-
I've only seen what's
it's an oversight that we don't have it, and I can only apologise for that.
And then he sets out a lot of other cases at 33.
Yes, and there's the reference to Mr. Justice Lloyd Jones. And at the very end, and this is a point that is part of the ratio, I think, in 36. The very end.
36, I think, is the other case I wondered whether that would be relevant. Bernardo's.
Is where we get to what is relevant for the judgment in this case is because he does rely on this point in his conclusions in relation to Section 4, that for a local authority to say that a child who would otherwise be in need, a child in need, is not, because his needs are being met by some third party, then the authority must demonstrate that the third party is actually able and willing to provide the relevant services. So the point there was, in this case, the Secretary of State was effectively saying, well, I'm not going to step in. And in those, for that reason and other reasons, Lord Justice Mumby said, well, the effectively Section 4 doesn't get the local authority out of Section 1710 on the facts of these cases. So that final point where he ends up is I think, probably part of the ratio of this judgment.
Well, I think for my part, it would be helpful to have copies of the Plymouth case and that Barnet case.
Well, we'll arrange for that to be done, my lord.
Thank you.
And again, apologies.
We should really see them, but shouldn't they should the appellant have the right to comment?
Well, let's see what it says. Yes.
So I think I've made my point about the local authority being entitled as a matter of public law to take other services into account, the fact that there's no logical dividing line that one can draw which sort of stops one at the immediate family, extended family, charities, schools, whatever it may be. And that the local authority is generally entitled to take into account the fact, and I stress the point, the fact that the problem that is at risk of occurring is going to be dealt with in some other way.
Well, I think the problem may not arise and the need may not arise.
Yes, that's
a better way of.
It was too. Sorry, that was too brief. Your lordship is right. It's to prevent the problem, the foreseen, anticipated problem.
It's too late. Section
Thank you.
20. Yeah, so it's to prevent a problem arising, to prevent a need arising.
Yes, your lordship. That's I was being too brief. Can I just then take, just to complete, I hope, the picture, just take your lordship's guidance we haven't looked at, if I can do that very quickly. It's we've looked, my Lord Justice Jerry Baker referred to paragraph 3.2 of the homelessness guidance. It's of a piece, as I said, with the working together guidance, which is the guidance specifically directed at the 1989 Act. You'll find that behind tab 26. And if I can pick it up just to show your lordships, first of all, at page 765, that it's statutory guidance issued under the Local Authority Social Services Act, to which local authorities are required to act under the general guidance of. The court may be familiar with the case of Rixon, which said effectively they have to follow it unless there's good reason not to. And then just skipping on, we've provided up what's only the relevant extract, 767, which is chapter 3 of the guidance.
Yeah.
We see there in paragraph 115 the distinction between early help and statutory services under section 17, and as my lord referred to, it's in
That's the footnote I was thinking about.
Yes, there's the footnote there, and then also footnote 41 is the child in reference to child in need reference. So the guidance is drawing a distinction between what it refers to as early help and part 3 services.
Early help is under the 2004 Act, isn't it?
Yes, I think so, and possibly, I suppose, also the Localism Act. We can see, in fact, we can see references to section 10 and 11 of the Children Act in the bullet point at the very bottom of that page. And then if we go on to paragraph 118, which is talking about...
Can I just... I'm sorry to interrupt you. What is said here at 40, what is that taken from?
Sorry, footnote 40.
Yes.
I don't know.
I asserted it was under section 10 of the 2004 Act, but that, I may be wrong about that.
I think the definition, I think this is the Secretary of State's definition of early help. I don't think...
In term of art?
No, it's not a term that's used in legislation as far as I'm...
No,
It's a description of, a shorthand for services that are provided otherwise than under part 3.
Okay.
And if we go over to paragraph 118, early help is support for children of all ages that improves the family's resilience and outcomes or reduces the chances of a problem getting worse. It's not an individual service, a system of support delivered by local authorities and their partners working together and taking collective responsibility to provide the right provision there. And of course, the court will be aware that the EYPP was a collaboration between the council, the local housing authorities, and the and NACRA as the provider. Some early help is provided through universal services, so that's education, health, that's available to everybody. They're universal because they're available to everyone. Other early help services coordinated by a local authority and their partners to address specific concerns within a family and can be described as targeted early help. Examples include ... and we can see there in the next line, housing. Early help may be appropriate for children and families who have several needs or whose circumstances might make them vulnerable. It's a voluntary approach requiring consent to receive the support and services officers. They may be provided before and or after statutory intervention.
I mean, this is very interesting. This is safeguarding guidance, isn't it? We're looking at working together as safeguarding.
Safeguard children, but I think it's general. It deals with safeguarding in the.
So this is actually describing. This is early on in the guidance. It's describing various types of support.
Yes. But
Right.
certainly it goes on to give guidance on how this should be undertaken. If we look at paragraph 131, we can see if the child will benefit from coordinated support, there should be a multi-agency assessment. So it's encouraging assessments of children and families for these purposes. 133, about 2/3 of the way down, the guidance makes the point: if at any time it's considered that a child may be a child in need as defined in the Children Act, a referral should be made to children's social care. So it's very obvious that at least the Secretary of State's position is that what's being talked about here are children other than children in need. This is not about children in need.
Well, there's a definition at 763 of what safeguarding is within this guidance, I think, is what my Lord was.
Right, so that's helpful. Thank you.
I think that's what my Lord was, I'm not sure.
Yes, I'm just. Yes.
It's not safeguarding in the statutory sense.
Okay. Thank you.
I think it's where it says safeguarding is for the purposes of this guidance. It's a whole lot of things.
It's a broad. It's using that term.
Okay. Thank you.
And the final point to note is just to really repeat a point that's made earlier. Paragraph 135. Specific local early help services typically include, and if one looks at the top of the next page, supporting secure housing. So again, the Secretary of State, at least, envisaging that acting in relation to accommodation is something that may be provided by way of early help. It falls short of statutory intervention. I don't think there's anything else I want to say on the law. We've expanded on some points in my skeleton argument, but I won't go through those essentially. And I'm very conscious of the time. I'll just try in about the next 10 minutes just to really summarise what our case is. I suspect I might be at risk of repeating what I said at the outset of my submissions. I won't take the court back to the assessment. The court's seen that. It sort of speaks for itself. The key points are the recommendation that was made by the social worker and, of course, the decision itself. And the decision itself is essentially to the effect that, in express terms, the appellant is not a child in need. He's got the support of his brother and his father. He's got that familial relationship, which will help him develop his independent skills and to do other things such as apply for benefits. It's recognition that the housing is not a long-term option, repeating what the social worker said, but we're going to have a meeting to refer him to EYPP. The step down to family solutions is, I think somebody described it as a social worker speech earlier on. Essentially what that means is he's going to be referred to the council's, the part of the council that deals with early help. As the judge sets out in his judgment, effectively the council, like a lot of local authorities, divides itself internally between what are referred to as statutory services, the Part 3 services, and it's often referred to as family solutions or something like that, which are services short of Part 3. And that will help him access any additional services that may be required. So the well-being services, the mental health well-being services that he needs. So the manager's simply saying, well, he's got familial support. The accommodation is going to be sorted out by a referral to EYPP. Anything else can be picked up by way of early help. In my respectful submission, that's a perfectly rational approach. It's brief, but of course these individuals aren't writing judgments. I think we've put a judgment by Lord Mr. Justice Jeremy Baker, as he then was, making the point that social workers' assessments should not be subjected to the type of rigour that were once subjected judgment to. But it speaks for itself. It's clear, it's logical, and its logic can't be faulted in my respectful submission. So can I just deal then very quickly with the arguments as they were put? The first criticism, this is going back, we are on appeal, of course, we've been talking a lot in terms of this for the first instance judicial review, but of course the court will be well aware of the fact that it's necessary to look at the judge's judgment. The main criticism of the judge is that he didn't adopt a forward-looking approach. Well, the first answer to that is, well, the judge can't really be blamed for that because that's not how the case was put to him. We've set out in our skeleton argument at paragraph 35 some examples of, by reference to the claim form and the statement of facts and grounds, of how the case was put. And the case was put that he was homeless at the point of assessment. And as I said, there was probably good forensic reasons for adopting that approach, but the judge can't be blamed for not adopting the sort of looking down the road approach. He wasn't asked to. And the passages that are complained about are essentially passages where the judge was addressing the case as it had been put to him by the appellant. So our first response is that the judge can't be criticised for not dealing with a case that wasn't put to him. In any event, even if one takes the forward-looking approach and one applies it, for all the reasons I've given, we say that the judge's ultimate conclusion was correct. That the appellant cannot show that the only rational decision open to the council was a decision that he was a child in need. And to sort of come from sort of full circle back to where I started, I suppose, the identified risk, to use that neutral term here, arose out of physical constraints on accommodation. In terms of the other needs, the appellant was going to be supported by his family and he'd receive support by way of early help. Even in relation to the accommodation issue, it was assessed as being okay, is the term the social worker uses in the short term, and only not ideal in the long term. It didn't seem to be an urgent or serious situation. There was certainly no immediate or imminent risk of homelessness. In any event, the accommodation element would be provided through EYPP. There was nothing in the facts of this case that compels the council at the point of assessment to conclude that the appellant required the additional suite of support that would have come with him being a looked after child. And finally, the council's approach was entirely consistent with the statutory guidance, that paragraph 3.2 of the Preventing Homelessness Guidance. It cannot, to my respectful submission, be irrational for the council to act in accordance with the statutory guidance. In the light of that, we say that the appellant's case just simply collapses, that the appellant cannot make out that he was a child or he had to have been treated as a children in need, and he's therefore now still a relevant child. In relation to what the judge said about the section 1710 test, in my respectful submission, the judge wasn't glossing the statutory definition. paragraph 69 to 70, he set out the party's attempt to persuade him to gloss it, and then he immediately followed by that by saying that I don't find either submission a particularly helpful gloss. In a way, he expressly disavowed any gloss on the statutory test, which he then went to set out. And the comment about it being not lightly met in my submission is simply picking up the point that my Lord Justice Lewis that Lord Phillips made in the P case, that every child has needs. The question is, are the needs A, serious enough to come within section 1710, and B, are they needs that need to be met by the local authority? What the judge was saying there is entirely consistent with authority. And there's nothing in here to indicate that the judge applied an erroneous test. But even if he did, he reached the right answer.
Thank you.
So, my lords, I think just about on time. Unless there's anything else I can assist the court with.
No,
those are my
thank you.
submissions. Thank you very
Thank
much.
you very much, Mr.
And
Moffat.
we'll arrange for those authorities to provide
Yes,
as soon as
it would be
possible.
helpful if you could be sent to my clerk fairly promptly. Thank you very much.
My Lord,
Mr.
may I just
Burtis,
make-
on that point, you won't have had a chance to consider those authorities yourself. I suppose you have had a chance, but
I've looked at the S case, and I can tell you if it helps what I say about that now, which is that was a case where it was not in dispute that the child was a child in need, even though the local authority was securing help from a third party. So that takes things nowhere. I haven't looked at the other case, I'm afraid. My Lord, it may be that both of us may need or
well,
want
would it
to
be,
provide
could
you
I,
with short additional
could I ask you
submissions,
and Mr. Moffat whether it would be possible for you to submit any further, and it would only be a paragraph
yes, of course.
each on those two cases by Monday. Close of play on Monday. Is that asking too much?
It's not. I can certainly do that.
Thank you very much. Ms. Moffat.
I'm on a plane to America at 10 o'clock tomorrow morning for a week.
Well, I wonder if this matter should be left to your junior, Mr.
Well,
Mr.
I mean, I'm sure we can lay. So by close of play on Monday, did your lordship say?
I did.
Yes, we'll manage that.
Thank you
I'm
very
looking
much.
at
I know it's
Mr.
a
Mitchell.
holiday, but they might have invented the internet in America. Your junior can send it over. Depends which part.
No, I think that these should be very short.
Yes,
submissions.
yes, no, I understand. I just
It doesn't sound as though S is going to help. That's the Plymouth one, is it? Or was that the
Yeah, that's the Plymouth one.
yeah.
Yes.
You looked at it, have you? Okay,
Can I make 4 points as briefly as I
thank you.
can? The first is in relation to what my learned friend says about how the case was run below.
Yeah.
Perhaps not, I don't know how far it influenced your lordships, but I don't accept that. I do accept there's been a shift of focus, but it was always the claimant's case that the future risk of homelessness was.
I didn't pick that up as Mr. Moffat's. What Mr. Moffat was driving home with particular strength, but there we are.
Well, my lord, it may be this, I don't need to say any more, but I can give you the paragraph references if
Well, why don't you
would
do
like.
that?
In the judgment itself, you can see the arguments being made, in particular at paragraph 71, 73 and 91
Yeah.
in the judgment, where Ms. Hannett says, there's a future risk, there's a future risk. The judge says, well, sorry, I need to look at the current situation. That's essentially what happens there. And there is reference to it in the grounds for judicial review. That's tab 14 in the core bundle, paragraphs 72 and 76.
Yeah.
The second point I want to make is in relation to what's been said about early help. My lord referred to the Children Act 2004. That is in the authorities bundle, but what it does not do in my submission is give any particular powers to the local authority over and above what they already have. There are two provisions. Section 10 of that Act, yes, forgive me, it's
Yeah,
The short point is that this is all about what local authorities should do when they are exercising their other functions. So what section 10, forgive me, I'm not quite got there yet. What section 10 is about is cooperation.
yeah,
So what it is saying is that you must make arrangements to promote cooperation between the local authority and other people with a view to improving the well-being of children.
What about 5A? Or is it just staff good services?
accommodation.
And contributions to a fund out of which relevant payments may be made? They,
Yes.
they can do certain things, can't they?
Well, they can. So what this is about is making general arrangements to promote the welfare of children. It's not about providing accommodation for particular individual children. The second is paragraph 11, which again is just about
Paragraph 11.
forgive me, section 11, or on page 87. And you can see from subsection 2 that again that's about making arrangements for how you exercise your existing functions.
Who's the relevant partner for these purposes? Would NACRA be a relevant partner?
NACRA could be a relevant partner, certainly within the meaning of section 10.
So functions in 11.3. Excludes, it doesn't give a list of functions that are included. It just excludes education.
Yes.
10.8, going back to page 84, 10.8 refers to guidance, and the working together document we looked at was issued under a variety of statutory provisions, including that one, including 10.8.
My lord, I didn't. I'm
so,
sorry.
Well, I made that in passing. So early help. So yes, what else you can say? There's something called
Yes.
early help system guide. I see from a footnote, which I've not seen.
Yes, the short answer is that there's nothing in here which specifically deals with early help or gives any additional powers to do that. What I say this is about directing local authorities to make arrangements to cooperate with partners to secure the welfare of children and to exercise their own existing functions with regards to securing the welfare of children. But
Are there any others? Is it your case there are no other statutory provisions? Early help doesn't have a statutory basis.
it doesn't have an express one. It clearly could theoretically fall within Section 1 of the Localism Act, which confers a very wide power on local authorities to do anything that a private person can do. So it's not my argument that there is no means by which a local authority could provide support to a child other than through Part 3 of the Children Act. That's not my case. What I am saying though is that the primary statute which deals with support for children who need help from the local authority is plainly the Children Act 1989. That's what Lord Hope more or less said in the G case. That should be the starting point. And there should be no attempt to strain to avoid the consequences of that by looking to other provisions which on any analysis are very, very wide. In terms of the guidance, my lord, it is statutory guidance, but it is guidance. It would, in my respectful submission, simply be wrong to treat what the Secretary of State happens to say about what the provisions under which early help is provided as in any guide to the law. It's necessary to apply the provisions of the Children Act 1989, and that is of course your job. And what the Secretary of
But
State thinks is
what
neither
Mr.
here nor
Moffat has
there.
said is that there is a category of low-level problem which doesn't require the provisions that the court to local authority to exercise any of its powers under Part 3 or Part 4 of the Children Act.
Yes.
Which this case fell into.
He does. And I don't deny that there could be such cases. I say this obviously isn't one of those cases. And just two further points on that. The first is that if a particular service is apt to fall within the scope of Part 3, then in my submission, really that is where it sits. And the existence of very wide alternative powers can't enable a local authority to take it out of Part 3 of the Children Act 1989. And the second point is this, is that, and it's a point I made before, but I just want to emphasise it, there is nothing wrong with support which could be described as early help in substance of the kind set out in the guidance being provided pursuant to Section 17. Nothing wrong with that at all. And that, in my submission, is actually where most of it should lie. My third point, my lords, is in relation to my learned friend's reliance on the comment by the social worker that the accommodation would be not ideal in the long term, and that, as he put it, there was no present problem at the moment. Two responses to that. The first is obviously there is that passing comment by the social worker in the care assessment, but you've seen the decision, which was made by the manager, and that is clear. It is not that this accommodation would not be ideal in the long term. It is that it is not a long-term option. That is the position formally taken by the local authority. The second point to make about that is that it is, of course, this is a case in which that longer-term problem was based squarely on the present facts. This isn't about a situation in which something is anticipated to change or there's something new coming around the corner. The accommodation we know is not suitable now. We know now it's not suitable in the longer term at the very least. So this is a present risk, albeit one on the local authorities case will have consequences later down the line. But we're not talking about
this case,
a new
though.
situation.
It's clearly the facts are not going to change in terms of the physical layout, but you're dealing with unlikely to achieve, maintain a reasonable standard.
Yes.
And can't a local authority say, well, 2 months is not going to prevent him doing that, 3 months, whatever. But if this were to become a long-term feature, then there's a problem.
Yes.
And must be able to say that, mustn't it?
They're entitled to say that, but in my submission, that's all I need to make up my case, because then in response to that identified future problem, they have provided services.
But that's what is an issue in this case. Did they say two things? Not at the moment, but he does need it, let's do something. Or did they say, not at the moment, if something happens according to NEST, then the problem will never arise. It really does depend on which of those two we analyse it as.
Indeed, and I say very squarely the former. This is clearly a situation in which the local authority is saying, we envisage a crystallisation of a problem we recognise now in the foreseeable future, and to meet that problem, we feel that we need to arrange for this child to have accommodation at EYPP, plus provide him with all the other services which go along with that, including, you'll have seen, my lords, some cash, which was actually explicitly provided under Section 17 of the Children Act 1989. My final point is in relation to the arguments about where one draws the line in terms of other services available. And just to be clear, I accept that a local authority is entitled to take into account that genuine separate third parties may provide the necessary level of support which would obviate the need for them to provide it. The most obvious candidates are the child's parents or other family members. That it could in some cases be charitable organisations. But what they cannot, in my submission, do is treat as falling within that category services provided by the Children's Services Department itself, which would fall otherwise within the scope of Part 3. And that's a very clear line, if it needs to be drawn. And I say this case falls squarely on the wrong side of it. It is important because otherwise we really could end up in a position where all a local authority needs to do, not necessarily deliberately, but is to say, actually, we're providing this service pursuant to a contractual arrangement with a third party, and or we're providing it under the Local Act. And by definition, the child can never then fall within Section 1710. That cannot be right in my submission. Or unless there's anything further I can assist you with, these are my submission.
Thank you very much, Mr. Purchase. And thank you very much for accommodating your submissions in time. We're very grateful to everybody in this case who's been working very hard, not just the two advocates today, but those who sit behind them. We're going to reserve our judgments. In due course, you will be supplied with a draft of our judgments to enable you to identify any typographical or other minor errors of fact. Obviously, an opportunity to re-argue the case. Please bear in mind the embargo on the publication or disclosure of that draft judgment at the top. You'll be aware of the recent cases in which this court has had cause to criticise those who've not complied with that embargo. Please do so in this case. Would you be kind enough to provide a draft order that reflects our decision when you submit your list of corrections? If there are any issues between you on consequential matters or ancillary matters, please provide short written submissions, and we will deal with those issues in writing. In due course, the judgment will be handed down electronically. There will be no need for the parties to attend. We will be grateful if you would provide copies of those two judgments and a very short note. I say no more than a paragraph each. I anticipate on those two cases by close of business on Monday. Thank you very much.
All right, table.